Well, friends, good evening. The topic of this video is going to be very relevant for all of us. We are all lawyers. So today in this topic, I wish to share some views regarding section 482 of Criminal Procedure Code, which is known as inherent jurisdiction of High Court. So you all are lawyer, you all know the definition, but one of the most important thing which needs to be seen in our section 482 Crpc, Criminal Procedure Code, that when this section is to be invoked before the Hon'ble High Courts, it is a very exceptional provision, and whenever anything, and you should keep in mind that any operation, CRPC is a procedural law, and the substantive law is Indian Penal Code, or there are many laws in which the procedure of CRPC is followed. So basically CRPC is a procedural law, and section 482 is a section which can be used in exceptional cases. Now, what are those cases which are exceptional? I will also tell you some of the examples, the kind of controversies commonly which is being filed by opting the remedy of section 482 of Criminal Procedure Code. This section is exceptional because if something which is not done by law, and if something is not done by law, and if due to that something the concept of justice is negated. Now, for example, we are filing applications commonly which we call them compounding, but mark my words, compounding is not a right word, because compounding is something which is vested before the trial courts, and there is a list of offences which can be compounded if both the parties agreed in an agreement that they don't want to pursue that criminal litigation. But compounding is not something which comes within the definition or within the jurisdiction of Hon'ble High Court when a petition of section 482 is filed, but commonly it is being used because the jurisdiction of criminal post 482 is inherent. It is above law. In criminal litigation, any law prevails, and if by executing that law or by following that law, if it appears to Honorable Court that if that law is to be applied in a given case, and if that application resulted into injustice, then it will be a case of abuse of process, and abuse of process is defined in section 482. So if in case of abuse of process, inherent jurisdiction may be invoked and proceedings of criminal nature may be quashed. Now, I was taking the example that we are filing an application. Suppose a litigation is launched by A against B of 420 or shall I say of any offences of a lesser degree. And if both the parties arrives to an agreement, so if in that case the trial will go, so then it will result into abuse of process, and consequently in those petitions the proceedings were quashed. So quashing is a power which vests in the Hon'ble High Court by opting the exercise of section 482 Criminal Procedure Code. Compounding has nothing to do, which is commonly filed. So now let us see the word used. Inherent jurisdiction, if there is any abuse of process of any court. Now, what is abuse of process means? If the process will go forward, then it will result into injustice, or it will not serve any fruitful purposes. Then this exceptional power is invoked. I told you in the beginning that exceptionally this section is used. An exception means the case which I have just given you. Supreme Court has said in many cases that in financial cases or in cases of a lesser gravity, however, gravity is also a different topic which we will discuss another day, you can broadly understand the offense which is of a lesser punishment. In those cases, if parties are agreed, so then proceedings may be quashed. Because law never permits so. Quashing is not permitted by any statutes. Quashing is not even defined in any law. Because see, 482, Criminal Procedure Code section 482 has an inherent jurisdiction to secure end of justice. The word uses or otherwise to secure end of justice. So set aside the law. If Hon'ble High Court thinks that this is something which is abuse of process, be it of any reason, then proceedings may be quashed. Because jurisdiction is inherent. It is above law. And commonly we have seen in the cases of financial offences, in lighter offences, or in cases of 324, shall I say, court, if party, then the proceedings may be quashed. Compounding is something which does not fall in C42. Or to understand what is inherent jurisdiction. Inherent jurisdiction is a jurisdiction which is unfettered. Unfettered, it means which is unlimited. That is why proceedings are quashed. Or if you see the real jurisdiction of section 482, it's an exceptional jurisdiction. In exceptional cases, in the case of Umang Kumar, state of Gujarat, in exceptional cases you see evidence may be determined by the court. But in cases, exceptional cases, so you have to establish the court. If suppose a case of a compromise, then straight away quashing may be filed in the offences which is of a lesser degree. But in some cases, if you are in a position to establish the court that if this trial will go, if this criminal proceeding will go, it will result into abuse of process and it will not achieve justice, then only this exceptional jurisdiction can be invoked. Thank you very much.